Hello, my name is Mike Ryan. The name of the show is Jury Duty, Make a Difference on BNN, the show that should answer all your questions about the one-day, one-trial jury system. Our guests today are Judge Kripalani, Maynard Kripalani from the Superior Court, and Assistant District Attorney Mark Lee, Suffolk County. Welcome. Thank you.
Thank you. Thank you
for being on the show. Judge Kripalani is a graduate of Washington College and received his law degree from the University of Virginia. He started his legal career way back in 1978 with Parker, Daly, Coulter, and White. Did I get that right? And went on to several other firms, including Wilson, Elser, Moskowitz, Edelman, and Dicker, one of the largest law firms in the country, correct?
Yes.
And was appointed to the bench in 2010 by former Governor Deval Patrick, and has written and lectured extensively about civil litigation. Mark Lee is the Chief Deputy for the Homicide Unit for Suffolk County. He's a graduate of Brown University and of Fordham University Law School. Worked as prosecutor for Kings County in Brooklyn, New York, before coming to the Bay State in 1997, and has worked at the DA's office since then. A former recipient of the Boston Bar's Prosecutor of the Year Award. He has also lectured and written extensively about ethical prosecution practice. Did I get that right?
Yes.
Okay.
Yes, by and large.
So today we'd like to talk about the attorney voir dire project, and I guess we should start off, Judge Kripalani, what does voir dire mean in the court?
Well, voir dire is the process by which prospective jurors are questioned by the court and now by the attorneys often to determine whether they, in the first instance, whether they can, as we say, stand indifferent in the case to be tried. And that means that they can be fair and impartial, decide the case without any extraneous influences or any biases or prejudices that might prevent them from deciding the case simply on the facts and the law that the court gives them. So voir dire is the process by which we question the jurors to determine if they meet that standard.
So in other words, if I go to jury duty and I go into the jury box, that doesn't necessarily mean I'm going to be on that jury, correct?
It does not. During the voir dire process, as the questions are asked, there may be reasons that the court determines that a juror cannot be indifferent in that particular case. Maybe they'd be fine in some other case, but the facts or the circumstances of that case present a situation where the judge determines that they cannot be indifferent, or the lawyers feel they can't be indifferent and they challenge to the judge. They say, we challenge this prospective juror for cause, meaning they're not indifferent, and here's why. So you can get in the jury box and then be excused for cause, and I think we'll probably talk about this later. There's also what we call peremptory challenges, that is, each side has a right to challenge or ask to excuse a certain number of jurors who have already been found indifferent, so suitable for service, without giving any reason to the judge. It's really a matter of their trial strategy as to who is the best set of jurors for their case that would be most receptive to their client's claims or defenses. So it's a matter of judgment for the lawyer.
So Attorney Lee and Judge Kripalani, you've been on this committee to implement attorney participating voir dire so that in years past, lawyers couldn't ask questions of prospective jurors, only the judge could?
Well, in years past, lawyers could participate, but it was not a participation as a matter of right. It was discretionary with the court. So if you wanted to participate in the voir dire process, you had to make a motion to the court and request it. And of course, that required the other party to agree as well. So since 1997, I managed to get that done twice, so it wasn't very frequent.
So Judge Kripalani, you've been involved now with some of these cases where the attorneys now can participate in voir dire.
Yes, I've tried since the new statute, the new procedures were implemented on February 2nd of this year, and I've tried a number of cases, both civil and criminal, involving attorney participation in voir dire.
Is this an option for the parties, or is it mandatory?
Well, it's the statute, which is Chapter 254 of the Acts of 2014, which is what established this new procedure, essentially, it creates a right to attorney-conducted voir dire. And I'll say attorney-conducted, but it includes self-represented litigants as well. They have the same rights as lawyers in this process. So there is a right to voir dire now, and by the attorneys. There's a standing order that governs how that right may be invoked. In other words, you have to file a motion, you have to describe the topics that you want to question them on. The judge may actually ask for the list of questions. It's at the option of the judge. So there is a right to voir dire, but how it's crafted or how it looks in the particular courtroom is still very much up to the discretion of the judge.
Now, has anybody in the Suffolk DA's office conducted trials under this new program?
We have a number of attorneys who have done so. I've encouraged all the lawyers in our office to seize the opportunity to participate in it. At the moment, we have one lawyer who's actually participated in the panel form of the voir dire, which is what some people view as the purest form of the voir dire process, but a large number of others have also participated in what's known as the sidebar voir dire, which is done out of the presence of the other jurors and just with the judge, the prospective juror, and the parties.
Judge Kirpilani, is the attorney-assisted voir dire, is that conducted prior to the challenges you mentioned, challenge for cause and peremptory?
Actually, no, it comes after. It's always been the case that the judge in the Superior Court or in the other trial courts has the obligation under statute to ask certain questions of all prospective jurors, such as do they know any of the witnesses or the parties, do they have a stake in the outcome of the case, things like that that would probably be or potentially disabling for their prospective jury service. So the judge still has to go through this process of asking the statutory questions, and then and at that point there may be challenges for cause, or the judge may decide sua sponte that I'm excusing this juror because I don't think they're impartial or can be impartial. At that point, the attorney-conducted portion of the voir dire starts, and the attorneys can now question the prospective jurors. If they believe that even though the judge has declared a member of the panel indifferent, they may still, as a result of questioning or an answer that was given, come back to the court and say, Judge, now I think you need to excuse this particular juror for cause, and here's why, because the answer they just gave.
So, Mark, what's the difference between, you mentioned sidebar, voir dire, and panel?
The panel voir dire is a voir dire that's conducted of a larger group of prospective jurors at one time, so simultaneously. And typically you'll have anywhere from 12 to 14 people put in the jury box, and then each lawyer will be given a set amount of time to voir dire or examine those jurors with regards to the specific issues in the case. But the dynamic is that you are speaking to a group and eliciting answers from a group all at one time. Whereas the individual voir dire is done individually, juror by prospective juror at the sidebar, so that at any given time it's just that individual along with the parties and the judge. You tend to get a little bit more privacy with the sidebar conducted voir dire. With the panel voir dire, you sacrifice some privacy, but there's some expediency in being able to ask one question that can cover the entire group in terms of if you intend to ask every single juror a particular question, now you can ask the group as a whole and work with different groups, different jurors, in getting different answers.
So several people could respond from the panel questions?
That's correct.
Now, Your Honor, do the parties meet before trial to discuss the mechanics of this, or they've been given training prior to?
Well, each case is a little different. So, as I said, the process starts with the parties bring a motion, and actually the other side may oppose some of the topics or propose their own topics to be covered in the questioning. So that happens at usually at the final trial conference in the criminal case, final trial conference in the civil cases, and a final pretrial conference in the criminal cases. So there's a discussion then The judge may issue, I typically issue an order after that saying exactly which topics are approved and any other ground rules I want to lay down. And then usually the day of trial, there's another discussion about exactly how this is going to work. And so there's really two opportunities to wait for the parties to get together with the court and discuss how it's going to happen. But there is a standing order that gives a lot of structure to the process to begin with. So between that and the fact that a lot of people in the bar and on the bench have gotten training, people are learning what to do, I think, pretty quickly.
It's interesting that parties can object to the other party's question during the voir dire.
Yes, and with the panel voir dire, obviously that involves the attorney standing up in front of the larger group of prospective jurors and making the objection. At the sidebar, it's fairly discreet and private. But yes, if I feel that the other side is asking a question that's not necessarily designed to determine whether a juror is fair and objective, but is instead designed to either indoctrinate the juror or to influence the juror's thinking about something, I might object to the form of the question and perhaps recommend to the judge that the question be asked in a different way.
Has that happened in any of the trials that you've been involved with?
So far, infrequently. What I see more of is when there are oppositions to the motion. The motion will say, "I want to ask about these topics," and then the opposition will say, "Well, we don't think that you should go into these topics for this reason. Like maybe it's too much of an intrusion into juror privacy," and so a lot of the things get worked out before the impanelment begins. But I have had a situation where a lawyer did object to the way a question was being asked, and I did request that the lawyer ask it in a different fashion.
So what's the feedback from your office, Mark?
The feedback I've gotten so far has been very positive. One of the things when I lectured within the office about the lawyer-conducted voir dire or the lawyer-participated voir dire, and I said, one of the things I said to the group was that everyone is basically starting off on the same foot, that nobody is more knowledgeable than anyone else is, and so it's an opportunity for a lawyer who's been practicing for 2 years to be on equal footing with a lawyer who's been practicing for 22 years. And the same goes for the judiciary. They're no more equipped to handle this on the fly than we are. And so I encouraged everyone to jump in with both feet, and I think that the feedback I've been getting has been generally very, very positive. Specific comments including, wow, the jury that I selected in this last trial, it was so much more meaningful and enlightening as we went through the process and I got to be a part of the process. I felt like I was making better decisions about who to keep and who not to keep. And I think that really stems from being able to participate yourself.
What about members, your peers on the Superior Court bench, Judge? Any feedback?
I think the feedback I get generally is that, honestly, as Mark pointed out, we all, judges or lawyers, came from a culture where attorney-conducted voir dire was not done even though the rules permitted it. It just didn't happen often. So the judges are as unfamiliar with the procedures as most of them. Some of them practice in other jurisdictions, myself included, but by and large, this is new to us. And so anything new, anytime there's change, you might approach it with some trepidation. Oh, it's going to take too long. It's going to somehow poison the entire jury venire with some question. And so, but I think the feedback I'm getting is that, well, this has not been, our fears have not been realized. This is working pretty well. It's not adding that much time to impanelments. Obviously, it's inevitable that it adds some time, so it's been pretty positive. I haven't heard of anybody with like some big complaint or horror story about something that happened in their courtroom. So.
Did you set a time limit for the questions?
I have not done that yet. My philosophy is that you give you give the lawyers the benefit of the doubt, expect that they're going to act professionally and responsibly in all aspects of trial, including the voir dire. And that, in my experience, has been they're not chewing up a lot of time doing it. They're being measured and judicious in their use of questioning. I think they realize that you spend too much time with a juror, they might get a little tired of hearing you talk. So I have not set time limits. The rules and the statute allow me to set reasonable time limits. And by and large, I haven't heard of many of my colleagues setting time limits either, but that's, at least anecdotally, it doesn't seem like that's happening a lot, that we're letting things take their natural course.
So you feel like it hasn't really added too much to the time of putting a jury together?
No, I mean, I think I'm actually involved in the data collection process for the SJC committee, and I mean, the data is still raw, and it's only been 6 months since we've been doing this, so it's probably too early to draw any conclusions. But it's adding some time, and the question ultimately will be, if it's that much of a burden, more of a burden, how do we deal with it? How do we meet that with resources? The legislature has spoken. We have attorney-conducted voir dire. It's so we live with it. But do we need more resources to handle the increased time it may take, or the increased load it may take? We are seeing an uptick in multi-day impanelments. That is, there are more cases that are taking than before that are taking more than 1 day to pick a jury, and so that's going to happen, I think, but by and large, I don't think it's added tons of time to cases. Again, the data will show generally that if the judge does it himself or herself, it's taking shorter time than if the lawyers are involved too. As I said, I think part of that's to be expected. It's inevitable, but there's a benefit. I think everybody perceives there's a benefit to the attorneys conducting voir dire for many reasons.
So you haven't noticed from your colleagues that it has measurably lengthened the trial process?
No, but it's not a big concern of ours whether it takes 2 days or 2.5 or 3 days to pick a jury. My feeling has always been that, drawing on my experience in New York, that it was and is going to take a little bit more time to pick a jury, but I felt the trade-off was absolutely worth it, in that the quality of the jury that is selected goes up as a result because of the extra time spent. But you won't find practitioners, at least I don't believe, you won't find them complaining about the amount of time that it takes, because they're the most invested in getting the quote-unquote quality jury. I think the judiciary has other things to consider, for instance, jurors' time, as well as the efficiency with which the court calendar gets moved. So those are things that I don't have to worry about, and so therefore the amount of time, generally speaking, is not a big issue for practitioners.
If I've done jury duty before, Your Honor, and I'm coming in and I'm going to be placed in a trial where you can have assistant attorney participating voir dire, should I be nervous? Should I be worried?
I don't think so. I mean, I've seen attorney-conducted voir dire for many years as a lawyer in other jurisdictions, and now for at least half a year here, and I haven't seen. I think that the privacy and the dignity of the jurors is being respected. I think the judges are required to explain to the jurors what's going to happen. I always tell them, if you've ever done jury service before, you may be in for, there's a new experience here, because the lawyers may ask you questions, and they may ask you questions about your experiences that are relevant to this case, your feelings, and about issues in the case, and that some of that may be somewhat private, but it's necessary part of the process to make sure that we get a fair and impartial jury, so that everybody gets a fair trial. And it's also tell them, as the standing order provides, that if there's something that they're asked that they would prefer not to answer for some reason, or prefer to answer in private, if, for instance, they're being asked as a group, they have the right to do that, and we tell them that. And I haven't seen or heard of many complaints from prospective jurors about this process. So I would say, no, I think you see a lot of jurors actually enjoy it, because they get to go in a dialogue with the lawyers about the issues in the case, and And some people like to talk anyway and be the center of attention. Others see that other prospective jurors are having a good discussion with the lawyer, and they're like, hey, that's not so bad. And so I don't think any juror should be concerned about it. And if they are, they can always raise that concern with the judge.
Now, you've seen this in New York, and you have people in your office who've worked these trials. Do they feel jurors are more engaged because of additional questioning from the members of the bar?
I think so, but it really depends on the approach that the lawyer takes. I think that is the key, entire key to a successful voir dire, is the approach that you take with the jurors, which is to say that it's imperative that you treat them with respect, that you understand that from their perspective it's an incredibly nerve-wracking situation, because the risk of being embarrassed is fairly high, at least in their minds, because they have no idea what the lawyers are going to ask them. They have no idea why they're being asked the question, and sometimes they get into their heads that there's actually a right or a wrong answer. And when you're sort of put on the spot like that, it can be nerve-wracking. So I think for lawyers, it really is important for them to give great thought and consideration to how you handle it and how you approach the jurors.
Does attorney participating voir dire enhance juror selection?
I think so. I mean, first of all, as a practicing trial lawyer, I very much appreciated the opportunity to question the jurors directly. I always felt that I had a much better that I picked a much better jury, and I had a much more insight into the jurors that were seated than the way it's been customarily done in Massachusetts, with a questionnaire and the judge asking some questions. It's impossible for a judge to know the case as well as the lawyers do, to know the facts, to know maybe the subtle things that might provoke a bias in someone. And so the lawyer's ability to supplement, augment, and fill in the gaps of what the judge has tried to do, and certainly I think historically the judges have produced unbiased juries too, but I think it's with the lawyers involved, everybody's doing a better job of it. And so I would also say that in addition to eliminating bias, one of the goals of voir dire is to, and this is part of the ABA standards on voir dire, is to facilitate the lawyers in making a more intelligent exercise of their peremptory challenges. So even though this juror has been declared indifferent, they're looking for the most or least receptive jurors to their client's case, claims, or defenses, and they're entitled to do that, and this helps them do that.
And you've seen this in New York and in here. Do you feel that attorney participating voir dire enhances jury?
Without question. I'm an enormous proponent of it, and I think it became very obvious during our committee meetings that I was an enormous proponent of it. I think that like anything else, it depends on whose hands it's in. The better lawyers are going to do a better job with it. But I think in Massachusetts, when I first came here, I was quite frankly shocked that the lawyers were not participating in any way whatsoever. And I think the new standing order gives an attorney a genuine opportunity to pick a fairer jury than we had before, and we have the ability to glean some more information from the prospective jurors and to make more intelligent decisions. And what I didn't like about it before was that in many ways you were making decisions based upon a number of cursory answers on a one-page questionnaire, which then caused many lawyers, including myself, and I'm sometimes embarrassed to admit it, to fall back on old stereotypes and biases and prejudices, which is not the way I think Massachusetts would like to conduct trials, and certainly not the judiciary, and certainly not me as a practitioner.
So basically, in the olden days, you just had the confidential juror questionnaire, and you would just...
And the judges would ask some questions, but the judges don't have the same incentive to ask the questions that I do, and rightly so. They have many more considerations to think about in managing a trial. So the fact that that I now have a hand in it means that I can have some control over the destiny of that part of the trial.
Judge Cripolani, is this expected once the pilot program is over? Will this move into district court, housing, juvenile?
Well, it's premature to say. The SJC committee, one very large component of the work at hand is to study the practices of jury selection in all of the trial court departments that use jurors. And that's an ongoing process right now. And it's expected that it probably will take more than a year to get a handle on that and decide what are the best practices for those individual courts. And then the SJC is likely to make some recommendations as to each trial court. So we don't know what those recommendations will be because we really are in the process of studying this. That's where we are.
Well, we've run out of time. I'd like to thank you at home for watching Jury Duty Make a Difference on BNN. Just remember, if you have any questions regarding your jury service, you can always contact the Office of Jury Commissioner online at majury.gov or toll-free 1-800-THE-JURY. That's 1-800-843-5879. You do make a difference. Please serve when called. It's important to all of us. Thank you, Judge Cripolani. Thank you, Assistant District Attorney Mark Lee. And thank you at home.